We are very fortunate in Texas to have the most awesome, the most practical estates code, bar none. And I teach administration of estates and guardianships to young lawyers to be at University of Houston. So after living with this code for over 20 years, I can't tell you how great and wonderful it is. I want to start with just the basic estate planning documents that everybody needs. First is a will. If you don't have a will, the state of Texas is going to determine where your stuff goes, and it might not be the way you want it to go. So you need a will. Everyone needs a will to say who they want to get their assets and belongings. The second thing a will does is it appoints somebody to be in charge of those, to be your fiduciary. Their job is to collect those assets, pay your debts, and then distribute according to the terms of the will. Sometimes you might have something special in your assets that you know only one person would really appreciate. A will allows you to give that to that person. It tells the world that I wanted this person to have my doll collection, or this person to have a special piece of jewelry. If you die without a will, as I said, Texas has an intestacy law, and it might not be what you want, and especially if there's second marriages. When I was with the probate courts, probably the most difficult issues we saw were children from a first marriage and a second marriage. But what a will should do is it should state who you want to have your money, who you want to have your property after death. It should appoint an independent executor to serve without bond to handle those affairs. It needs to revoke any prior wills. And another thing it can do is if you have minor children in your will, you can state who you want to be the guardian of those minor children if, heaven forbid, both spouses or both parents die together. Or if there is a divorce, and perhaps you know that the surviving spouse is the natural guardian, but you really wouldn't want him to handle the money. You can appoint someone else to do that. You need to understand some terms when you're thinking about drafting a will. One of them is community property versus separate property. Community property is everything you've accumulated during your marriage. Separate property is that property that you came into the marriage with or was given to you by gift or inheritance. So it has a different connotation. In a will, you can do trusts. I know you've probably seen the ads, avoid probate, do a living trust. These can be used in certain circumstances, but when I had clients come in and say, oh, I read about this living trust, I can avoid probate. And I say, why? Our probate laws are so simple. The process is so simple. But if you have a second marriage, sometimes a trust is a good idea. If you have property outside the state of Texas, real property, a trust saves you having to open a probate in another state. In a will, you can do a trust. Like I've talked about, you can name a guardian for your minor children, but you can also set up a trust where whatever those assets that go to that child will be managed for him or her until an age. If you do not have a trust and a child gets it, at 18, they get it. Now, how many 18-year-olds do you want to get a large, sizable inheritance? I've seen one in 27 years of practice that I felt could handle it. So you can think of the thousands I saw that, no way. You can set it up where it can be 25 or 30, or they get portion of it at 21. If they mess up, they get the next portion at 25, and hopefully they've learned some stuff. A trust is very important if you have a special needs child, a child with autism or mental retardation, where you can put those assets for them in trust, and the trust can be designed in such a way that they can still receive government benefits. But there's some very special language that has to go in that trust. And the one thing you don't want them to do is to lose their government insurance or their Social Security or whatever benefits are available to them. If you have an older spouse that maybe you're concerned would not be able to manage those assets, that's another reason to use a trust. Two others that I ran across is what I call the carrot and stick approach. I had a client who was terminal, and he had two daughters, and one of them was in high school. She was very smart, but he was very concerned that she did not have the gumption to go to college. So we wrote what I call the carrot and stick trust. When she graduated from high school, she got X number of dollars. If she went to 2 years of accredited college, she got X number of dollars. If she graduated from college, she got X number of dollars, and the trust would terminate at age 25. If she didn't get a college degree, it was tied up until she was 40. So that was our carrot and stick approach with her, and it worked. The other issue that sometimes a trust is needed for a child is if there's substance abuse issues. Alcoholism, drugs. You can write a trust where the trustee is mandated to pay for the rent, pay gasoline, buy groceries, but not get cash. I've seen trusts where they actually have urine tests. And as long as they stay clean, they get to be taken care of. But if the test comes back negative, they either have to get in a program or there would be other dire circumstances. So that kind of covers what you can do with a will. A will is as creative as you and the lawyer come up with based on your special circumstances. And that's why I feel it's very important that if you're drafting wills, you really need to get a probate lawyer, one that knows what they're doing and will do it properly. I saw thousands of wills in my time with the courts, and some of them were drafted by lawyers that had no clue what they were doing, and there were problems with the will. The second document that you need to have in your estate planning arsenal is the durable power of attorney. Now, these next three documents I'm going to talk about are all things that affect you while you're alive. The durable power of attorney is a great document, but it's also one of the most scary documents because what you're doing is you're appointing an agent to be in charge of your assets while you're alive. It can be immediately or upon incapacity. So if incapacity sets in with this document, someone can step into your shoes, manage your assets, pay your bills, but if you choose the wrong person, they can also take your assets. So it's very important to pick the right person. Partnership with this one is the power of attorney for health care, and it's exactly what it says. You're appointing an agent to make medical decisions for you should you be incapable of making it. And the incapacity could be like long-term dementia, or it could be that you're having surgery, and maybe while they have you on the operating table, something comes up different that could be taken care of. Well, the doctor can go out and talk to that agent and get permission to take care of it. The third is the directive to physicians. It's also known as the living will. I refer to it as the pull the plug. If you are terminally ill and the two doctors say you're going to die within 6 months, you're telling the world that you do not want to stay alive hooked up to machines. You want to be kept pain-free, but you don't want to be artificially kept alive. And the last is one that, depending on the family dynamics, you may or may not need. This is a declaration of a guardian should the need arise. Occasionally we would see where someone who was appointed under a power of attorney was abusing that duty. And another family member would have to come in and apply for guardianship in order to extinguish the power of attorney. By having this declaration, you're letting the court know who you would want should the need arise. I want to take a few minutes now to go into other things that people aren't aware of that might be of benefit. But before I do, HBU has put out a great little booklet that if you're going to redo your will or you're going to draft a will, it's little questions to ask. Fill it out. It will make your attorney's job a lot easier. It also kind of forces you to think about alternatives, alternative executors, alternative beneficiaries. So it's really a great book. So please pick one up. I think you'll find it handy. I want to talk to you now, as I said, about other things that kind of encompass probate and estate planning and elder law. And I want to start first with elder law scams. In the past 6 months, I've had every one of these called because I'm now a senior too. One of them is the live person will call and say, I'm with Microsoft, something's wrong with your computer, give me your information, send me money and I'll fix it. The newest one, and this has happened in the last 30 days, is you will get, and it's probably the scariest for seniors, you will get an automated call that says, I'm with Social Security and we're getting ready to suspend your benefit due to irregularities. Please call this number. Now that's brand new, and as I said, in the last 30 days. One that's kind of a twist on it that's been around for a long time is the IRS. You'll get a very authoritative call. This is Agent John Doe, badge number, blah, blah, blah. You owe the IRS money. We're getting ready. We have sued you. We're getting ready to seize your house and property. I have that played on me. My 93-year-old mother-in-law lives in Baltimore, and I just happened to be home when she got that call, and it upset her. She was getting ready to call them back. And we were there for about 4 days, and she got 2 calls in 4 days with the IRS scam. From the standpoint of the internet, you've got to be careful of the Nigerian emails where somebody says, I have $3 million in a bank in Texas or in the United States, and I need someone to help me get it out. Similar is I've seen some where the bank logo looks so much like Chase, Wells Fargo, Compass. They're never going to send you an email to get account information. They don't do it. Call if you're unsure. And my very favorite one, and I'm meaning that sarcastic, is the grandma call. And this is how it goes. Ring, 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 ring. Hello. Grandma, is that you? Yes. Guess who this is? So you think, well, it's grandson. Bobby, is that you? Yeah, Grandma, it's Bobby. And I'm in trouble. And don't tell my parents. They would just kill me. I need help. And at that point, they've either had a car wreck and need $500 or $600 to fix the car, or they spent money and they need money for tuition. They never ask for a whole lot of money, but the plea is, don't tell my parents. They'll be so mad. You're the only one I can turn to. And those are out there, and I knew about them for years and finally got one about 4 months ago, and I don't have any children. So I started by saying, Grandma, is that you, Johnny? Yeah, Grandma, it's Johnny. And I wish I had let him finish the spiel. But I was so angry at that point that I said, I don't have any children, which means I don't have any grandchildren. And I probably shouldn't have said this being a Christian, but I said, I hope there's a special place in hell for you. And I hung up the phone, but now I wish I had heard what he had to say. The reason the elderly are picked for these millions and millions of dollars losses is many of them are lonely, and it's a friendly voice on the phone, or only 1 in 7 is reported. And that being is either they're embarrassed or they're afraid that if they tell their children, they'll lose their independence. So just be aware of things going on, and especially be aware for your friends also. Now, going into some other things that I think you need to know about. Let's start with Medicare. Many people are first, Medicare, as you know, is a federal insurance program that after you reach the age of 65 will pay for medical benefits. There's 4 parts to Medicare. Part A is your hospital service, post-hospital extended K, like rehab services, home health care, and hospice. Part B is your physicians' services and medical equipment. Part A is part of Medicare. Part B you pay for separate. You pay a monthly premium. Part C is these HMOs you see advertised on TV all the time and would replace A and B. You're part of an HMO at that point. And Part D is for prescription drugs, but you got to have, they pay for part, and then there's this lapse, and then they pick up at the end. So it's designed, there's a big deductible if you take a lot of medicines. What Medicare does not pay for is nursing home. And many people think, well, I've got Medicare. I've got my nursing home covered. No. If you are in the hospital 3 days, and you probably have always wondered, what's the magic number, 3 days? They keep you 3 days. And you need to go for rehabilitative services, then you can go to a nursing home. But you can't go from your house to a nursing home. You have to go from a hospital at least 3 days, then they'll transfer you to a nursing home, but it's strictly for rehab. And it will only last 100 days. They'll pay the full cost, and it lasts 100 days, the full cost for 20 days, and then after that, there's a copay of $170 a day. So remember, Medicare does not pay for long-term nursing services. One thing, if you're on Medicare, you need is what's known as a Medigap policy. This is the policy that supplements Medicare, and everybody should have one, or else you're going to be paying these huge deductibles that can wipe out savings and any monthly retirement benefits you're getting. So everybody needs a Medigap policy. Some companies offer them, not many, but AARP, there's a lot of them out there. You just need to kind of do your research and figure out which one is best for you. So you're thinking, well, what pays for all this nursing home care? That's Medicaid. And Medicaid, to be eligible for Medicaid, it's low income. So you have to basically spend down your assets, and then you are eligible for Medicaid, and Medicaid will pay for the nursing homes at that point. Now, there are lawyers out there, and they're very, very specialized, that do Medicaid planning, where you can take your assets, put it in a trust, protect them, and get Medicaid. But there's only a handful of the lawyers that do that. But if you're getting to that point where the assets are kind of low and you see them just being spent down all the way, then you might want to talk to one of these attorneys. You've got to kind of set it up 5 years in advance. Question that's fairly recent is, does Medicaid get my home upon my death? Starting in 2005, Texas started a program called the Recovery Program, Medical Estate Recovery Program. If there's not a surviving spouse or there are not minor children living in the house, they can go after your house if they have been supporting you for several years on nursing home. Now, in the real world, you get around, the exemptions usually take care of it. The house has to be worth over a certain amount, and there is a way to avoid it. Texas is not a real creditor-friendly state, and as a fourth-generation Texan, I feel like I can say this, that many of the founding fathers that came to Texas were escaping debtors in the East. So when our laws were drawn up, we have a lot of things that other states don't have. We have the homestead exemption. You have a family allowance. You have exempt property. And the creditor statutes you can run at death. Most people think, oh, statute of limitations on legal, 2 years, 4 years. Well, on a creditor, it's 120 days. And most creditors are not aware of how short it is if you follow the steps. There's certain steps you have to follow, then you get that clock start ticking. I used to mark it on my calendar. I remember one time I had a gentleman that his wife passed away, and she was bedridden for several years and discovered QVC and ran up a lot of debts, and he wasn't even aware of it. And he was talking about cashing in his retirement to pay those debts. I said, no, we're not going to do that. And we were able to eliminate about $25,000, $30,000 worth of credit card debt doing the statute and following the rules of the statute. Along with dealing with seniors there's a whole lot of different type of residential daycare facilities. Should you need them, should your parents need them. There's daycare centers that are run through the city. Some of the churches have daycare centers. They have in-home services that are available for someone that just needs assistance. Then we have our retirement centers, and there's different levels of retirement centers. You've got independent living, like the Forum, where you have an apartment, you live pretty independently. They have a communal dining hall, they have transportations to the doctors, to the shopping. They plan recreation activities. For a short time, my mother lived in the Forum, and it's like, what do you give her for birthday, Christmas? She doesn't need anything. So I arranged with the recreation director to give her tickets to whatever they were doing, whether they're going to the theater or a museum or a movie. So she always had a gift certificate from me for activities at with the recreation program. Next level up is assisted living. And this is where you're getting more services than just being in an independent living, usually 24-hour supervision. Next level down, I'm going from least amount of care to the most amount of care, are personal care homes. You could have one in your neighborhood and not know it. These kind of remind me of the boarding homes of years ago, except 24-hour care. They prepare the meals, they dispense the medicine, and they assist the residents with bathing, dressing, grooming, and eating. Many of them are owned by social workers, and they're all over the county. They are a lot less expensive than a nursing home, and they're a good kind of middle of the road where you have a loved one that needs 24-hour care. Perhaps you're working or unable to physically give that care. And the last and the most care is your nursing homes that are manned with doctors and nurses and continuous supervision, and that's probably the most sophisticated level of care. But I want you to be aware there are other levels before you get to the nursing home, because the nursing home is also the most expensive level of care needed. I have seen people plan these great estates, and then they pass away, And we find out that most of their assets are in a bank. And we go to the bank and find out that, nope, doesn't go to the estate, it has right of survivorship accounts. So all that estate planning kind of went out the window. You have different levels of accounts that you can set up with a bank. One is multiple party account with right of survivorship. That's what my husband and I have. We're on all the accounts. Should one of us die, it automatically passes to the living one. We have some that are called payable on death, where I'm in charge of it, it's my money, but upon my death, I can name who I want to get it. And if the only thing in the estate is a bank account, this is probably something to be looked at. The third that a lot of people aren't aware of is called a convenience account. This is where you need someone on your account to sign checks if you're unable to. Before my mom passed away, I was a convenience account signer so that should she be in the hospital, I could continue to pay her bills. And the only time I ever went and did anything with that account is to pay her bills. Let's see what else. I've talked a little bit about trusts, but I want to go a little more into the trust. With a trust, you have the grantor, that would be you, setting up the trust, naming a trustee who is your manager for the benefit of someone else. Now, you can do a trust for yourself with you as the trustee, but should you become incapacitated and you define what is incapacitated, 2 doctors certifying, someone else can step in. When I was with the courts, I remember a case where the attorney came to me, and it was a pretty sizable estate, and the husband had died, and the wife was co-trustee with the bank. And the bank became very concerned because Mama couldn't say no to her kids. And she was running through her money very, very rapidly. And they were concerned there would not be enough to support her. They were also concerned about some capacity issues. And they came to court to have her declared incapacitated so that they would be the sole trustee, and they didn't have any trouble saying no to the kids, where she couldn't. And it protected her assets so she had enough to live on for the rest of her life. Now, the living trust, that's that avoid probate. We used to see the ads all the time, and you still see them. That's where while you're alive, you set up a trust. And the only problem I saw with these is to make them effective, you have to transfer all your property into them. If you leave any piece of property out, you're going to have to come to probate court and have a will probated. The living trust is really good if you have a second marriage situation because a trust is harder to break than a will. It's also good, like I said, if you live in Texas and you have a ranch in Oklahoma or a property in Colorado, then if you deed that property into the trust, you avoid having to go to Oklahoma or Colorado or California or whatever and setting up an ancillary probate, which can be very, very expensive to do. I mentioned guardianships, and we saw as many fights over mama or daddy and guardianships. And I'll just be blunt. He who controls the guardianship controls their inheritance. There's 2 types of guardian. They can be the same person or they can be different people. Guardian of the person, which is kind of like your durable power of a health care, they take care of all the health care needs. They take care of the body. And guardian of the estate, which is like the durable power of attorney, they take care of the estate's needs. And occasionally I would have a client say, well, you know, my daughter is the accountant. You know, she's the banker. I want her to be guardian of the estate. But my son, I'm closer to him. You know, I know he'll take the best care of me, so I want him to be guardian of the person. And if your estate planning documents fail, this is what you're going to end up with. Now, the issue with these is they're totally court supervised. The guardian can take no steps without getting court permission. The guardians have to be bonded for the amount of the estate. So there's a lot of protection there also. But everything they do has to have court permission, and of course that means having a lawyer kind of on retainer for as long as the guardianship is open. You have to file annual accounts. You have to account for every penny and show all your receipts. I remember one time I filed an annual account, and I was like a nickel off, and I had looked, and I couldn't find the nickel, and I finally said to court, can I just give you the nickel? Can I give? No, you got to find it. We finally found it. And as I said, the guardianship is only when you haven't gotten your duck in a row and you haven't done your estate planning documents, but you reach the point of incapacity. Okay, some of the other things that I'm kind of a fan of is pre-need burials. It means you're making the arrangements. When a loved one dies, there's grieving. And the grieving can sometimes cloud sensible judgment when you're planning a funeral. I have seen funerals for as little as $3,500, and I've seen them for $45,000. And the funeral people, the directors, they're very kind, but they also have products they're selling. And I think some things to consider, and it's probably the best thing that you can give your loved ones, is to have your funeral planned. I know when my mother died, she had her funeral planned. She had the verses she wanted spoke. She had the songs she wanted sung. She had her pallbearers. I mean, it was all there. The only thing we had to do was select a dress and pick the flowers, because my mother loved flowers and she would want seasonal flowers depending on when she died. And it just makes it very, very easy on the loved ones to have this done. Plus, you can have it paid for. You can pay for it monthly, you can make a lump sum payment, but you're in charge when you are not going to be grieving. You're not going to be making those decisions when there is emergency or just the grieving process, the emotional process. You will go in and say, no, I don't need a $10,000 casket. That $3,000 casket looks real good to me. And you can make those decisions in a rational manner. Now, what if you have a situation where the parent, this is usually one of the children, comes and says, there's no pre-need funeral. I don't have the money to bury Dad, but Dad has a bank account, or Dad has a life insurance policy. Our wonderful estates code has a way, a method, where you come to court, we sign an order ordering that money be paid directly to the funeral home so that the burial can take place. We also have the same format for safe deposit boxes, where someone has put their will in the safe deposit box. The son is not on the safe deposit box, but he's pretty sure that's what the will is. And there's a court order we can give you that will allow you to open that safe deposit box. And the bank officer takes the will and is responsible for getting it to the court. He does not give the will to the applicant, because what if they're not in the will? Suddenly that will might disappear. So they can get it to us, and most banks know how to do this. Just kind of going down the list of things, let's talk about driving. You have a loved one that you know should not be driving. You are afraid they might hurt themselves or someone else. And they are not going to let you get that driver's license out of their little hands, because it's their independence. There's a couple of ways you can do this. First of all, if they're in a car accident and the officer thinks there's capacity issues, he can report it. The doctor can report it. Your family doctor can report it to the Department of Public Safety. And when you're filling out your license application, which as you get older, you have to go in, you can't do it by mail. If you indicate some kind of medical condition that they think might affect your driving, this can affect it. After receiving a report, they don't just say, you lose your license. There's an administrative procedure where you meet, you look at the physical problems, you might need doctor's letter. If your license is suspended, there is a right to appeal. But I have found in some cases where if you, I know my stepfather was one of these who was starting to have dementia, and he did not want to give up that driver's license, and my mother was very concerned, so she put it on me. And I remember sitting him down and saying, the one thing he loved more than anything was my mother. And I said, Papa, you would not want to hurt Mother, and your driving might cause it to happen. And he had gotten the letter. And I told him, if he wanted to fight it, what he'd have to go through to get it. And he handed me his driver's license and never drove again. So sometimes you've got to figure out a way to approach it. You don't go in saying, you're a terrible driver, let me have your license. You try to figure out, and I guess each person is individual, how to approach them where maybe they'll give it up voluntarily to help. Elder abuse. This is something, I hate to say near and dear to my heart, but I've given a lot of lectures on this to lawyers who do not, believe it or not, realize their ethical duties, but also to the public. If you suspect elder abuse, you are mandated to report it, just like if you saw it with a child, and to not report it is a misdemeanor. We all know if you see a child being abused, you pick up the phone and call CPS, say, I saw this happening. But the same applies to our elderly, our seniors. And I used to give this speech to lawyers, and they're thinking, oh, attorney-client privilege. I can't tell anything. I can't say if he said my son did this to me. It goes out the window in elder abuse. It does not apply if your client tells you something that is elder abuse. It also does not apply to the doctor-patient privilege or the clergy privilege. Anybody that is hearing or sees or is told about elder abuse has a duty to report it. And you are protected by reporting it. The laws protect you as the reporter, and there's a couple of ways you can do it. You can call Adult Protective Services and tell them you can be anonymous. You can give them. The other thing you can do that's a lot quicker if you live in Harris County is we're fortunate enough to have 4 probate courts. Each of those probate courts has a court investigator. If you write a letter up there saying, look, I think this is going on with my neighbor, it can be elder abuse, exploitation from a family member, but it also can be self-abuse, not eating, not taking meds, just somebody needs to check on the situation. The probate courts are going to be quicker because they'll get that court investigator, or they will appoint an attorney to go out and check out the situation. I remember one time I got a call from the court saying, look, we need you to check on this older couple. Police officer at the bank, security, he was an off-duty cop, was noticing that a neighbor was bringing them in, and it started out being $100 a week, and then all of a sudden it was going up to $500 or $600 a week. And he was concerned. He reported it to the courts. They appointed me to go out and check out what was going on. I went to their house, and they didn't know me from Adam, but immediately opened the door. Let me walk into their house. I walked into the refrigerator, and there was 1 package of chicken wings. I looked in their cabinets, and there was maybe 2 or 3 cans of soup or vegetable. I just remember there were only 2 or 3 cans. And their car had already disappeared. The guy had already gotten their car. And it was obvious they didn't have any children, so they had nobody to take care of them. And I ended up filing a guardianship to make sure they were taken care of, made sure they had food. Ultimately, we moved them to an assisted independent living. Found a real nice one that would allow them to have their little dog, because they had two dogs. One was a vicious little chihuahua that tried to bite me. The other was a sweet dog. We found a home for the vicious one, and the little one they took with her. So there are assisted living places that will allow animals, but a lot of people aren't aware that you are required to report it. Along with this, you're thinking, well, where does she get all these wonderful ideas? The Houston Bar Association puts out the Elder Law Handbook. I was fortunate enough, because now you have to download it online, and it's like 30-some-odd pages. But at one time, for several years, I was the editor of this document. And how it came about is the Houston Bar Association called me up, called a couple other probate attorneys up and said, look, we want to put out this handbook. And we want you to think of every question you can possibly think of that a client has asked you. And put the question and answer it. And we had, there was a gentleman at the Houston Chronicle that was willing to do the artwork. And that's how the Elder Law Handbook came about. It spawned over that if you go to the Houston Bar Association website, there's one for family law, community, consumer law. I don't know, there's about 3 or 4 handbooks now that you can get. But to get one bound is difficult, but I was able to get some, and they're back there on the table for you to take home. If you are young and you're figuring out how can I approach my parents with this subject, this is a good starting point. Mom, I went to this seminar. This lady attorney talked about elder law and probate, and we talked about so many things, and I just want to talk to you about it, and even have a handbook we can go through together. Last thing, if you want to change your will, or the reasons to change your will, it's what I call life changes. Something happens in your life that could affect your estate planning. It could be a divorce, a death. If you move out of state, you might need to have the will redrawn by an attorney of that state. Any kind of crisis situation, you need to think, okay, how does this affect my estate planning? How does it affect my will? Maybe you have a will that says when I die, I leave it to my son and daughter-in-law. And all of a sudden, they're getting a divorce. That would be a life-changing situation. Or maybe just anything. You have a better idea of what's going on in your life. Maybe you realize that your child is not as responsible or has married somebody that's not as responsible, where you might want to look at a long-term trust. There was a family that started out with very little. They were self-made, very, very wealthy with the company they started. And they were when they first started off and when the children got married, there wasn't much there, but now there was an estate of several millions. And they were they had 2 or 3 daughters, I can't remember. They were concerned about their son-in-laws, just running through the money because they had proven they weren't real responsible. Life-changing situation. They went from moderate assets to mega assets. And the need was to change the estate planning documents so there was a trust to protect their daughters. So that's all I have. Thank you very much.